Blow the whistle with E-Daily Law.
Yo, 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 whistleblowers, what's up? I'm throwing flags on the plays. I'm protecting your stuff. Hello, everybody, my whistleblowers, as I affectionately call you. It is another episode, a live episode of Blow the Whistle with E.J. Lee Law. So we are doing a live episode today where we're going to be talking about the next technical file that's coming up, where we're going to be talking about why you should avoid using popular brands. And what I mean by that is a lot of times I find that clients or just people in business are inspired by brands that they have been exposed to for years. And so a lot of times you think that those brands are available, those names are available to use them on products as long as you make a change in one word, or you're using it on something that's completely unrelated to what that product or what that brand is generally known for. So we're going to look at a couple of trademark examples that I have found scrolling through social media that I think are teachable lessons. And also, just so you know, as I've mentioned before, as far as the USPTO is concerned, all of those records are public. So that means that anyone can search them and research what these records are indicating. So, you know, before you work with an attorney, if at bare minimum, you should be going to the United States Patent and Trademark Office as part of your technical file number 5 of brand due diligence, where you're actually checking to see what trademarks have been registered with the USPTO. And so that's another little piece that bugs me as a trademark lawyer. You are not trademarking your brand. You are actually registering a trademark, because for a brand to have a trademark, you have to be using it. And so you register a trademark, you register a service. Given registration, you're basically putting other business owners on notice that, hey, this mark is acting as a source identifier for my product and service. And the USPTO has acknowledged that, and I am being given registration within a specific protection class all over the US. So the first thing we're going to do is we're going to talk about a trademark application that I saw that was discussed on social media. So everybody's into Birkin bags as of late. Hopefully you're familiar with Birkin bags. They are a very expensive style of handbags and all things luxury, if you will. And so we have a ton of designers that are inspired to, make their own brands. I'm not sure how long Hermes has been around, but they are the owner, the parent company for Hermes bags. And so I came across a post for someone who is actually trying to register a trademark where the trademark says "fuck a Birkin." So I'm going to share my screen with you guys, and you're going to actually look at what's being filed. And also the other piece with this is because the USPTO has received a gazillion applications, applications are taking a lot longer to get examined. We're talking about anywhere from 8 to 9 months before your application will actually get anyone to review it. So this application, I believe, was filed in March, but hey, we're going to go right there to it so you guys can see what I'm talking about. All right, so I'm going to head back. Hopefully you guys can see this and put in the actual mark. And we're going to talk about why this isn't going through. So first of all, this person filed for the trademark of "fuck a Birkin," and excuse my French if you don't curse. And they based it upon what is called the 1A filing status, which means that is based upon actual use in the marketplace. Now, notice here the actual name of the company is called Jazz Originals. Now, even if your LLC is a completely different name from what you're putting on your products, that's okay. But again, it still has to be acting as a source identifier. So we're going to actually click here on the TSDR, which is the trademark status and document retrieval. And we're going to look at the actual specimen. When it comes to handbags, clothing, anything that has some type of hanging tag, when what you're trying to get a trademark registration is on the front, or it is what we call like centered in a way that it's more ornamental. Usually what's going to happen is the USPTO will come back and say that this will not receive registration because it is ornamental in nature only. We don't see a hang tag that's indicating that Fucker Birkin is acting as a source identifier for this piece of this handbag piece, if you will. So more than likely, that is the first reason why this trademark probably will not get approved. The second reason it's probably not going to get approved, if it was to even remotely get past the preliminary stage, is that Hermes would fight this. The moment they got notice of Fucker Birkin, which is despairing their baby, their brand, I don't think they would be too pleased if this was granted a trademark registration. And so what would probably happen is the Hermes company would file what's called an opposition. And they would basically, in an opposition, you're basically saying that registration of someone's trademark would be detrimental to your business, and you would have to provide evidence as to why. So again, going back to this young lady's, or whoever this is, their application, we see that they filed this application themselves. They did not have any help in doing this application. So I'm pretty sure that when this comes back, and obviously this was filed in April. So if we count, let's see, April, May, June, July, August, September, October, November, December. So this application probably will not be reviewed until sometime in December of this year. But I don't anticipate that this is going to go through. It's very rare that you're going to be allowed to insult another brand and be able to use that as the basis of a trademark registration. Okay, so we're going to go back and we're going to check another application that I think is worth looking at. Recently, I was on, and I'm going to come back on the screen for a second here. Recently, I was on Twitter, and I noticed a young lady is releasing a clothing line, and it's called the PC Collection. So I was looking at the clothes, and I thought, oh wow, it looks really nice. So I wanted to see what she was talking about with her brand, and I noticed that the P and the C stood for Paris Chanel. So I imagine there are a ton of aspiring budding entrepreneurs that will see Chanel and are inspired to do their own clothing lines, inclusion, whatever, blah, 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 blah. But there is a difference between being inspired and causing confusion in the marketplace. So obviously I did a check. There is no trademark registration specifically for Paris Chanel, but it would likely be denied because we already have a Chanel brand for various things, including clothing, purses, perfumes, you name it. I believe Chanel has been around since the early 1920s. So we're going to actually look at some of the applications that were denied registration because, again, they were using a part of the Chanel name in a way that would probably cause consumer confusion in the marketplace. So we're going to go over to that really quickly. And if you guys have questions, feel free to ask. Let me make sure you guys can see this because that happens sometimes when you can't add to the stream. All right, and we're going to go and see how many applications have been filed for Chanel. So as you can see, guys, there is 265 records for Chanel alone. When you're searching records, notice you have three options here. You have the option to check both live and dead records. And live simply means that the trademark registration is somewhere in the process. Either it has actually received registration because you're given a serial number when you first sign up. And then after you receive your registration, you're given an official registration number. If it is dead, it could be dead because the registration was refused, or if a registration had gone through at some point, that particular business owner did not keep up with the maintenance documents that are required. So again, we're going to click here on submit query again. I'm going to go back and just look through how many records we have here, but I can just kind of tell which ones probably were refused because of causing confusion. Now, this one, interestingly enough, is by the Chanel company. This was something that they applied for. We're going to just look, and I just want to see what exactly they applied for. But again, it's such a wealth of information. And so if I could encourage you to do anything is before you're launching your brands and you're wasting money on marketing dollars, at least go to the USPTO to check and see that a name is available. Now, just because there might be an indication that the mark that you're planning to use is available, you need to also further research as to why, because someone else might have avoided registering a trademark because it was not feasible in terms of acting properly as a source identifier, or in the alternative, there could be some other reason as to why a trademark doesn't go through. So at bare minimum, you want to check the USPTO, and then in the other side, you would like to check maybe Google and just do a soft search just to see what comes up organically. Because the way I look at it is like this: you would rather be a small fish in a big pond, but we know about you at least from looking through USPTO records, versus if you're out there all willy-nilly, and because you don't have a trademark registration, and if you're not coming up in the organic records, there's no way for a competitor to know to avoid getting that trademark or using that name in the same way that you are, because you're not in the system. There's no way to figure out where you are, whether they probably have not checked social media, they haven't checked doing Google business records, whatever the case is. So it's always imperative to try to at least check USPTO records just to see what's out there and what's not out there. So the other point of me coming on here and going live is because I want to encourage you guys to participate in asking questions. This is a great time to do that for free, talking to myself, but also keep in mind that there's a disclaimer. Obviously, this does not create the attorney-client relationship, but at least you get some information, and it's entertaining as well. So one of the other things that I wanted to talk about is a question that I get commonly. And one of those questions is like, hey, Attorney Lee, I want to register the trademark, but I haven't started using it yet, but I just want to go ahead and apply for my trademark. So I have to tell clients that when it comes to having a trademark registration, you have to actually be using that trademark on a product or service before you can ever file for the trademark registration. So unlike things that fall under copyright, trademark is not an absolute property right. You have to actually use it. And so you can get preliminary approval. There's a process for that. And we've seen that happen before. In fact, I'll actually show you guys the trademark applications that Kanye West filed not too long ago for, I believe it's technology for his mother's name. And so we'll look at that really quickly. All right, Donda. So there are 29 records that Mr. West has applied for, and we see that several of them are dead, in fact. So let's just go back and we're going to look at just the live records. All right, so for this first one, it looks like he has filed for 9, International Class 9, which covers tablet computers, portable computers, audio speakers, audio electronics. And he filed this under what I've mentioned to you before is a 1B application, which means that you're basically letting the USPTO know that you have an intent to use this particular mark, but you're trying to get preliminary approval before moving forward, right? So we're going to click on the next record. For this one, he is going to be doing handbags of all sorts, from beach bags, book bags, carry-on bags, duffels, diaper, gym. Yeah, he's doing a lot there. And these applications were filed in July. So he's already received the preliminary approval as of June 8th, 2021. All right, let's go to the next one. 45 for internet-based social networking and data services. 44 for nutritional consulting for individuals and groups in the field of achieving energy balance through appropriate nutrition and achieving and maintaining a healthy lifestyle. I have a feeling that Mr. West is not going to actually provide every last product or service that he's filed preliminary applications for. I just don't see it. But then Kanye West is one of those people who likes to be known for all things to everybody. So we'll just have to see. 41, obviously, which covers a lot of entertainment services, but in this case, it's for online journals. I'm not going to read through that list of things, but if you guys want to check it, feel free to go over to the USPTO and you can see some of the things that Mr. West has filed for. This one is for charitable fundraising, which I can see him doing something with that. 25, which is for clothing, which is something that he's already doing anyway. This one is for cosmetics, which to me, I feel like he's taking a page out of his soon-to-be ex-wife's catalog. 41 for jewelry. No, I'm sorry, 14 for jewelry. 42 for home design. And the last three, 35 for retail stores, some type of broadcasting cable television he's going to be doing with the name. And lastly, but certainly not least, it looks like he has a specific design mark for, oh, wait a minute, this is not even his. That's funny. This one is for an Asian company. But it doesn't look like they've done anything with it either. Interesting. All right. So another question I wanted to discuss was, I'm reading, hi, Julia. Thank you for participating. I really appreciate you. And I see, he has all the money to file as many applications as he wants. So yeah, so that's the thing to keep in mind. If budget is an issue, please don't be filing all these applications. Well, you won't be filing all those applications because you don't have the funds, because you're given 6 months from the date of actually receiving preliminary approval to actually start using those marks with those products that you've applied for. You can file extension fees, but again, you can file for an extension, which will give you another 6 months. But again, if you do that, it's a fee. So obviously, Mr. West has money to burn to do that. But for the average person, if you're not planning to actually do something with it, I don't recommend it. So the other thing that I'm going to check really quickly is I want you guys to see the applications that Beyonce filed for her children's names, which is also similar to what Mr. West has done. So for Sir Carter, this was filed back in August of this year, interestingly enough. But for Sir Carter, she's filed for 1B status again, which is intent to use. And that's for everything from fragrances to DVDs, baby teething rings, carriages, metal keychains, bags, small leather goods, mugs, banners of cloth. So like swaddling blankets, clothing, hair accessories, playing cards, producing products for other people. And lastly, of course, entertainment services, namely online video games, dance events, as it relates, I assume, to her son. So yeah, the rich and famous file a lot of 1B applications because they're trying to prevent quote unquote fans from trying to profit off of their children's names. I believe Tom Brady did something similar to a nickname that he had that he was trying to prevent um, fans from trying to file a trademark registration using that nickname. And I think it was refused as far as him trying to stop it because he didn't have a bona fide intent to actually use the trademark. He was just trying to stop other people from using it. So, that's just something to keep in mind. But hey, you got to have money to burn to try to fight these people. So I wouldn't recommend doing that. But all that to say, as it relates to this particular live, was that again, when we're talking about using popular brand names, keep in mind that these brands have the opportunity to file what is called an opposition based upon the theory which is known as trademark dilution. So you guys know of Snickers for candy. This is an example. If we were to allow Snickers to be used on, say, an airline or Snickers home bedding and accessories, it weakens the strength of what we know Snickers to be, right? And so that is why those brands, famous brands only, can stop trademark registrations for brands that are using them in a way that is not related to what it is that they do. I've seen Starbucks do it. I've seen, who else have I seen do it? I would not be surprised if McDonald's has done it. But the point of the matter is you're being inspired by these brands because they've been around for so long. And so you're thinking that they're free to be used as long as it's not in the same genre. Or in the alternative, you add maybe one or two different other words to where you're feeling like that allows you to stick out from the original. So again, I'm going to go back, to the Chanel records so we can look through those a little bit and see some of the ones that were actually denied registration because of the likelihood of confusion in the marketplace. See, what was it? Chanel. Anybody have a Chanel bag? I don't have a Chanel bag. Not quite sure I want one. Let's see. Chris Chanel. So this application was filed back in June 2019. And this person filed for Chris Chanel for shirts. Hopefully you can see that. All right, just want to make sure you guys can see that. All right, so when an application is being refused for whatever reason, you receive what's called an office action. And usually in the office action, it gives you a summary of the issues as to why registration is being refused. And so when you file a response, you have to address each one of the items that is being brought up in the order that you received it. That's the best way to do it. But the main thing here is this first reason for refusal, which is the 2D refusal, likelihood of confusion. So we're just going to read this part. It says the registration of the applied for mark is refused because of a likelihood of confusion with the marks. And it gives you the registration numbers for all of those marks or for that particular brand. And I'm pretty sure every last one of those are the Chanel brand. As it says, in this case, at hand, applicant seeks to register Chris Chanel in standard characters for shirts. The first cited registered mark is Chanel in standard character for swimwear stockings. The second cited registered mark is Chanel in type form for ladies' gloves. The third trademark is CC Chanel, is an illustration, which includes for blouses, skirts, sweaters, cardigans, dresses. The fourth cited registered mark is Chanel for suits, jackets, blah, 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 blah. So as you can see, Chanel has a number of trademarks using Chanel. Now, obviously, they don't have Chris in it, but because Chanel is such a strong trademark, it's been around for years. It is a very famous brand. This is the reason why people a lot of times are coming up with quote unquote Chanel, not because they really are using it, but because they have only heard about it in the marketplace. They know of people who have bought Chanel, that maybe there's someone that has patronized Chanel themselves. But the point of the matter is you didn't just come up with that on your own. And it's a lot harder for you to be known as Chris Chanel when Chanel already exists in the manner in which they do. This person filed for 1B, so we don't know exactly how they were planning to use it. And there were some other issues in this application, but I wanted to focus solely on this likelihood of confusion issue because I get a lot, I see a lot of applications out there where clients are being inspired to some degree by other famous brands and figure they can use it in some way on related goods or in other situations on unrelated goods. So you're going to have one of two issues: the likelihood of confusion. On the other hand, an opposition is going to be filed if you, by the miracle of God, got past the preliminary approval stage and you have been entered into the official gazette, and a company comes back and says that, hey, we think that you should refuse registration for these reasons. So it's just so much easier for clients to avoid these things by coming up with your own branding that is unique to you. I know it's easier said than done, and sometimes clients, unfortunately, to be completely honest with you, are lazy. So I missed where you made a comment, Julia, as to your question, so that isn't necessarily true. Remind me what you're referring to. I forgot. But just so you guys know, so this is the first of many lives that we're going to be doing, but you guarantee that I'm going to do the playbook review the first Tuesday of every month. And so I want you guys to participate, invite people over to the YouTube channel to ask questions. We'll review applications. We'll talk about the latest IP news. As you know, we're doing the 12 technical files that I see most often in the IP world. And what I have to bring you guys is next when it comes to stuff like that. And as I've said before, you might not always like what the ref says, but you respect it. And so that is what I want you guys to get from this. Especially since, you know, I talk to my relatives and family members about trademark things and all of the different things that they want to do. So this is an opportunity to share that information, not only with you all, but for you to share that information with your friends as well. As you all know, I also have the Referee Whistle Official DIY Trademark course, which is now a video download with a workbook. And then we also have the Q&A follow-up that goes with that course as well. So we are scheduled to be doing that coming Saturday. And so if you've taken the course and you have questions as it relates to filing your own trademark registration, I highly recommend participating in that. And the links will be posted in the description box. And if you're on my email list, I will make sure you get that information as well. So lastly, before we end for the night, because we are almost at 30 minutes, I got a question earlier today about GIFs. So the GIF. So some people say GIF, some people say GIF, some people say memes, but they're all the same. And so the question was whether or not you could register the copyright for a gift. And the way I look at it is this: gifts are usually taken from something that is already under copyright. And what I mean by that, gifts are usually from some type of video, it's from some type of photograph. And so usually the underlying copyright is within that piece of material. So you're not going to necessarily register register a copyright for a gift itself, that little piece. You're going to be registering that for the actual thing that it's based upon, if that makes sense. So for instance, if I take a photograph of myself, like a selfie, and somehow that selfie becomes a gift. Maybe I want to become a gift one day. Like I hope one of y'all take a gift from one of my videos and make it and make something out of it, and it goes to millions of people. That would be freaking awesome. I would die a happy woman if somehow my face became a gift. But all that to say, the underlying video that I'm recording right now is what I would register as far as the Copyright Office is concerned. And then so the gift would be considered a derivative work of the original piece. Same thing with photographs, same things with, like, there's a ton of memes from The Office, the TV show with Steve Carell and all the various other actors on that show. I use those GIFs all the time because whatever emotion I'm trying to capture, you can probably get off of Office. So it's a really funny show. But again, like I said, guys, we're going to be doing this the first Tuesday of the month, and maybe every once in a while I'll make a impromptu video, but I want you guys to ask questions. I'm just going to double check to make sure that there aren't any questions as of right now. And I actually meant to go live on my Instagram, but I didn't get a chance to do that. But we're going to do this again because this was fun. I enjoyed doing this, and hopefully you guys got the chance to see the trademark applications. So the next time, let me see before I go back, Julia, that if we just added some more words to it, the application will be approved. No, that's not necessarily true. In fact, I've seen many instances where it's not approved. However, I will say it also depends on what you're filing for. So going back to the example about Chanel, there is a trademark registration that went through for someone using Chanel in the name, but they're an entertainer. So the young lady is a rapper out of Atlanta. I forget the first part of her name, but she goes by blank Chanel, and that got approved for her as an entertainer. Now, if she tries to do anything else with that name, as far as like merchandise is concerned, she's probably going to have some issues there. Trying to get, trademark registration like the other application that I showed you for Chris Chanel. So just because you make some changes to it does not mean you're going to get it to go through. So again, let's just be creative and come up with our own stuff instead of being inspired by what's out there in the marketplace. Hopefully that makes sense. But again, guys, this is Blow the Whistle with EJ Lee Law, where we're doing the playbook review. And I hope that on the next episode that you guys are going to be asking tons of questions and showing up and showing out in the marketplace, because I want you guys to be Referee Whistle official out here with your brands. And so we're going to be doing this again. So I'm going to end this live, and I will see you guys next month on Tuesday at 7 p.m. Peace out. Oh, before I go, you can also get in touch with me if you want to make a consultation at 678-343-2799, or you can also reach me by email, which is contact@ejleelawpractice.legal, and I will make sure all of that information is in the comments. So I will see you guys soon.